I will now start sharing my PowerPoint presentation. I hope you can see it.
Yes,
up here. Very good. I'm trying to put it in a big format like this. You can see it better. So yes, I will really, in 25 to 30 minutes, it's a challenge to present the whole of design law in the UK and the EU, but that's what I aim to do, so that you have an overview of what it is all about. And I welcome any questions at the end if people have questions. So what am I going to talk about? I'm going to present to you the different intellectual property rights that can be used to protect designs in the UK and the EU. Then I will tell you what the legal instruments are for these different rights. And then I will present to you very shortly the different aspects that we have in design law, and I will focus really on EU design law, which still applies in the UK because the UK, even if it has exited the European Union, as you know, because of Brexit, it still the European instruments have been retained in UK law for the moment anyway. We may depart in the future, but it's not on the books right now. So that means I will show you what is protected by design, that's the subject matter, what is not protected by design, that's the excluded subject matter, what you need to do to prove that your design is protectable, that's the protection requirements, and then talk briefly about who can own a design right, then what the rights of the design owner has, what kind of infringement test we have, and then the exceptions to these rights, these economic rights, and finally how long a design right is lasting for. So what are the different rights that one can have, a designer, when he designs something? And it could be a very nice sari, for example, or some Indian beautiful designs I'm sure that you can think of. There'd be graphic designs, or they could be in 3 dimensions, like the proper aspect of clothing. You think automatically probably copyright, because in Indian copyright law will be probably the same, because it's inspired from UK law, works of artistic craftsmanship, and that includes clothing or other types of design, like furniture can be protected by copyright, but also graphic designs or 2-dimensional design like a poster, for example, or wallpaper. So you think of copyright, but there are also other rights which give even more protection. These are registered design rights. And in the UK, we have the UK registered design right, UKRDR for short, and the community registered design right, that's the EU right, which applies all over the EU, which gives a monopoly right, in the sense that you do not have to prove that the person has copied your design in order to sue. You just have to say that they made a similar design, it looks the same or similar, and that's enough, even if they didn't copy your design. Whereas an unregistered design right, it's a bit like copyright, it's an anti-copyright. Like in copyright law, you have to prove that the design has been copied by the defendant in order to sue and win in the litigation. So in the UK, we have a situation where we have a UK unregistered design right, and then we used to be able to have the community unregistered design right, but because of Brexit, we can't anymore. So we've transformed it into something now called a supplementary unregistered design right, the SUDR. So we have an odd situation where we have 2 unregistered design rights which look very similar. So we are in a process in the UK of probably reforming these rights in the future, in the next year or 2. I don't know how long it will take, but we might do that. And then there are obviously trademark rights, and that's the registered right. Like you register your design, you register your trademark. And if you don't register your trademark, you can use passing off or unfair competition if you're in the other member states of the EU. So the tort of passing off, that probably in India you have something similar as well. It can protect some designs as well. So you have a possibility to accumulate all these designs, all these rights for your designs. And as long, of course, as you meet all the conditions. So if your design, say the wallpaper, can be protected by copyright, a registered design right, unregistered design right, and trademark, and even be protected under the passing off action, you may as well sue on all these rights. And it is very frequent that it happens. Now, in the UK, we have obviously the Copyright Act, And as I said, the UK UDR, the unregistered design right, and they are regulated in the UK Copyright Act, which is called the CDPA of 1988. And then at UK level, we have the UK Registered Design Act of 1949. Again, they've been amended mainly by the EU legislation, and this EU legislation is the Design Directive, which dates from 1998, and the Design Regulation, which dates from 2002. So in the EU, we have the Design Directive and the Design Regulation. In the UK, we have the RDA and the CDPA, and the RDA still includes bits of the Design Directive, but we are not subject anymore to the Design Regulation, unless, of course, a UK resident wants to register its design in Europe, like an Indian person would as well. Then they have to comply with the requirements of the Design Regulation. So that leads me to talk about what is actually a design. So a design is defined differently, whether you want to have a UK unregistered design right or if you want a registered design right. And it's important because whether you apply, and this would be the same for an Indian person who want to apply for a community registered design right, or a UK registered design right, the exact same law applies. And this is Article 1 in the directive, which there's a corresponding article in the regulation, which says that a design is the appearance of whole or part of a product resulting from the features of, in particular, the lines, contours, colors, shapes, texture, and or materials of the product itself and or its ornamentation. So what does that mean? That means that you can protect two-dimensional and three-dimensional designs equally. So it's a very broad definition, but it is really to do with the appearance. So here I put my emphasis on the word appearance. It's the appearance of the product, not the sounds, smells, or tastes, which could in some laws be protected by copyright or by trademarks, but not by design. And it's not really at all relevant that the design is appealing. So it's appealing to the public, let's say, that there is some aesthetic appeal to the design. So you can have designs that look really ugly to some people, but that doesn't matter. They can be protected by the registered design rights system. On the contrary, when you look at UK UDR, and I won't talk much more about it because I don't have that much time today, it's only protecting mainly three-dimensional products. There could be some products that are in 2 dimensions, but have a sort of a shape and would be protectable by the UK UDR. The important thing is it does not cover surface decoration. So think of a pot, the shape of a pot could be protected by the UK UDR, but anything that you decorate the pot with, so the decoration of the pot would not be protected, but that doesn't by UK UDR, but that doesn't matter because you could have copyright for it, or you could have a registered design for that decoration. Now, the registered design, again, the directive, but as I say, it's the same in the regulation and in the RDA, the Registered Design Act in the UK, also defines what a product is, because you have to have, in order to be protected, it needs to be the design of a product. So a product is an industrial or handicraft item. So you see, it doesn't have to be made by hand. It could be made by a machine, and includes, for instance, parts to be assembled into a complex product. It can include packaging, get-up, graphic symbols, typographic typefaces, but it doesn't include computer programs. They are protected by copyright law. And then it explains to you what a complex product is something that can be assembled and disassembled with different components and can be basically repaired. So it's a design of a product, and it's very broad. So a lot of things can be protected in the UK and the EU by registered design right. Now, as I said, it includes graphic design, it includes environmental design, so landscape gardens, for example, an oil rig, a bridge. It could also be the typical designs that we think about, like household furniture, cutlery, fashion design, and all bags and shoes, etc. So what is excluded? Well, what cannot be protected? I already said computer programs cannot be protected, but there are designs which fall within the definition of a design that I just explained, which would be excluded for several reasons. And one of them is because they're solely dictated by their function. And there's been a very important case that the Court of Justice decided to interpret this notion. That's the Dothrham case. And that basically, the purpose of this is to say, well, if it's solely dictated by function, that's for patents to protect, not the design right system. Then there are also interconnection features. So interconnection features is things that you need to, design of things that need to interconnect. So think of an exhaust pipe, for example, that needs to be connected to a car. That little bit of the design of the exhaust pipe that connects to the car is excluded in most cases because it falls within this exclusion. Why do we have that? It's because we want to encourage repair and that you have independent repairers and it cannot be protected by a design right. But there's an exception to that in the sense that if the purpose of the design is a modular system, think of Lego bricks. So the purpose is to build and that these Lego bricks interconnect with each other, then that can be protected because that we want to incentivize production of these modular systems. Then obviously we can't protect designs that are contrary to public policy or morality. There are several decisions by the European Office of Intellectual Property on that. For example, a sexist or racist design wouldn't be protectable, obviously. And then there are certain things you cannot protect, but this is a normal sort of IP principle, like a pure idea or a pure method or pure principle cannot be protected by designs. And then there are features that also must match. So, for example, you have a car that has a bonnet, any car will have a bonnet, will have a roof, it will have review mirrors, doors, etc., and they match. So if you put the roof of a Volkswagen over the car that's a Ferrari, for example, it won't match. Okay, so there are certain things that you should be able to reproduce again as an independent repairer, so they're excluded from protection of by design law. Now, what do you have to prove to prove that you can have this design right? It's novelty. And there's two main conditions, novelty and individual character. But this novelty, I've just reproduced the text of the law, but this novelty, the important bit is obviously that, it has to differ from previous designs, but I'll go faster here, the concept is a relative novelty. For those who know patent law, in patent law, it's an absolute novelty. If I find a piece of prior art hidden in a temple in the middle of the forest somewhere in India, and nobody before had ever seen it, but it exists, it is there, it will destroy the novelty of that particular thing that I want patented. But in design law, it's not like that. You can see here the law says that except where these events could not reasonably have become known in the normal course of business to the circles specialized in the sector concerned operating within the community. Community means the European community. So that means that if the designers of that specific sector, so let's say it's a piece of furniture that's in that temple, it couldn't have normally been known in the normal course of business within the European Union and the European community that this piece of furniture, looks like this, then it will not be considered to destroy the novelty of the design. So it is a concept of relative novelty. Now, the important thing is you need to basically look at the prior art. So how do you look at the prior art? You look at when your design has been made, when you want to basically register it, and you apply for this design at the UK Intellectual Property Office or the EU Intellectual Property Office. And you look at everything that's been published before, or if it's not been published, it has to be exhibited or used in trade or otherwise disclosed before the filing date of the application to the Intellectual Property Office in question, or the priority date. For those who do not know that, I can explain in the Q&A afterwards if people have questions. So your prior art is everything that's been published or exhibited before the filing date of your design. And except this a concept of relative novelty that I just explained. And of course, if you had disclosed your design in a confidential agreement with someone and have breached that confidential agreement, obviously that will not destroy your novelty. And there is also a system that if you have disclosed your design within a 12-month period before you file it, then that will not destroy the novelty either, because that's a sort of grace period to let people experiment and see if in that period of 12 months, you are able to get a lot of sales and you want to transform your community unregistered design right into a community registered design right, you have that 12 months period to do it. And of course, if there's been a bit of abuse, and abuse is, for example, stealing the document. Somebody comes into your office and steals the document on which you have recorded, or let's say drafted, drawn your design. So in these cases, you still have novelty and you can prove the novelty and get your design registered. Now, that's the first requirement. The second one is individual character. And this is a bit closer to what in copyright law we would call originality. Again, I've reproduced there on the slide the text of the directive. It has to do with the overall impression and how the informed user sees the design. And if he sees that it differs from other designs, then it will be protected. And the informed user is not the person in the street, and it's not the technical expert, so the very informed designer. It's somebody in between. And there have been cases that have discussed this concept of informed user. Now, once you've proven all this, you become the owner. And normally the designer is the owner of the design right, of the registered design right. And only if the designer actually is an employee and has made the design in the course of employment, then is the designer not the owner, but his employer who employs the designer. If there is a commission, and it's not a concept of employment here, I'm basically a consultant, or the designer is a consultant. In that case, he remains the owner, and you have to have a contract. So the commissionee is the designer, yeah, and the commissioner is the person who wants or pays the designer to have this design made. So in this case, it's very important to have a contract, because if you don't, then the ownership remains with the designer. What are the rights that the designer gets, or the owner of the design, pending, if it's the designer or the employer? Well, they have, if it's again a registered right, only talking about registered rights, this concept that I said of monopoly, in the sense that you can sue if the person who, the defendant, did not have the consent from you to make the design. Okay, and use or making of the design is very broad. It's making the design, offering. You don't have to make it if you're just offering it for sale, for example, putting it on the market, importing it, exporting it, using a product in which design is incorporated, stocking the product in a warehouse, for example. And that's a non-exhaustive list. The important bit is that you do not have to prove copying, that the person, the defendant, has copied your design. Even if they came up with this design independently, so long as you can waive your certificate of registration of your design and it's proven that it's novel and has individual character, you will be able to win the case. Now, before I talk about the exception, the infringement test is the same as the individual character test. So if we go here, it will say in the directive that what happens is, if the overall impression on the informed user does not differ then from the overall impression produced on the user by the other design, then it is infringed. Okay, and it's difficult, therefore, to prove that your design has been a little bit difficult, has been infringed because of this informed user, because the informed user will look at things very carefully. It will not look at the design in a hurry. Okay, and so it might encounter differences and think, it's different, and so therefore the overall impression is different, and therefore it's not infringed. What are the exceptions and the term of protection? Well, if you are dealing with the design in a private way, you're experimenting at home, you're copying the design for fun, you make a little drawing of it in your room, in your bedroom, and don't do much more than that, then you're not infringing. If you're experimenting and trying to make the design better, so you're making the design and sort of try to make something a bit different, but you have to reproduce the design in order to experiment, then you are not infringing either. You can also use the design for citations. So you can reproduce it to quote it or to teach, for example, under certain conditions. And there's been also a Court of Justice case on that exception. And there is also the same exception for those who know a bit more about patent law, where you have an exception to facilitate transport. So if, for example, an Indian plane would come over the UK and land, and on it there would be an infringing design, but then in the next hour it flies back to India, that would be fine. There wouldn't be an infringement of the design. And the term of protection is 5 years, and it is renewable. So your registered design right is for the first time registered only for 5 years. You cannot automatically register it for more than 5 years, and you have to renew it every 5 years. And for this, you also have to pay a fee to renew it. And the maximum time you can renew it is 4 times. So you can renew it 4 times, and the term will be 5 times 5, 25 years. And the difference is for the community unregistered design right, it lasts 3 years. Just for your information, the UK unregistered design right lasts about 10 years. There's specific rules, but overall it's about 10 years. So they have different terms of protection. And my last slide is about the future. Like I said at the beginning, the UK has exited now the EU, so there may be some reform of design law in the UK. It's not been announced yet, but I know that because I'm also sometimes consulting for the UK Intellectual Property Office, and I learned this from them. They're thinking about it, but it is for sure that in the future there will be a revision of the directive, the EU directive. There's been a consultation, and I have reproduced here the link for people who are interested. And thank you very much for your attention. As I said, if people have any questions, they can ask me. If they want to email me, here's my contact detail. And if I don't know if there's any students in the audience, but if they want to study for an LLM, or if they want to become a PhD student, I'm always happy to receive emails. Thank you.
Well, since the series is on intellectual property rights, we need not worry about the concepts or the definitions, the laws, so on and so forth. But nonetheless, we can see that when we are talking about the 21st century, we always say that we are living in the knowledge era. And long time back, sometime in 1997, I came across this wonderful statement which enthralls me even today. For more than a century, the world's wealthiest human being has been associated with oil, and today he is a knowledge worker. So that statement was in respect of Bill Gates, who was successful in converting the knowledge into property. That is going beyond the saying that knowledge is power. And the remaining I need not mention, but the fact is that in countries like India, there has been a lot of awareness relating to intellectual property, because we realize that the creativity, the innovation, and the benefits thereof are not confined only to the technocrats or highly educated sections of the society, but also to every section of the society, of the country. Therefore, even the rural sector, even those areas which are not exposed to intellectual property protection, they should get the benefit thereof. So this is what our National Intellectual Property Policy 2016 says. And intellectual property, as we know very well, is considered to be private property. TRIPS agreement also says that IPRs are private rights. But at the same time, there are certain kinds of property which not only take care of the private interest of the stakeholders, but also the community interest, the group interest. And that is mostly witnessed in the case of geographical indications of goods. That is the topic of discussion today. and the intellectual creations which are combined with certain geographical factors. They offer a wonderful or an amazing array of benefits to the producers, to the users, and also to the proprietors, and thereby, the successful commercial exploitation of which will yield many fruitful results. This is one important aspect. And you must have heard about the geographical indications of goods. And people start talking about basmati, then American basmati, then Rights-8, then they talk about, so many other better examples, well-known examples like even champagne and all. And Karnataka is full of geographical indications of goods. I am aware of it, right? Like whether it is, the Bidri work from Bidar or Mysore silk or, even this Hubli, Dharwad Peda. There are so many agricultural goods, manufactured goods, then even the natural goods which attract the intellectual property protection. This is one important area. But one unique thing we need to understand is that we are not talking about the individual benefit, the individual interest. We are talking about the group interest or the community interest which can be advanced through this unique regime of intellectual property, whether it is the weavers associations or the associations of producers of handicrafts or certain manufacturers of a unique kind of food or dish, so on and so forth. All of them stand to gain from the intellectual property protection, which is conferred by law and which is regulated by some of the authorities. So this slide speaks only about the concept and nature of intellectual property rights, which is self-explanatory. Probably I need not explain anything beyond this. Now, coming to the intellectual property, as you know very well, by nature, the property confers limited monopoly rights, because, in fact, it can't be kept in the private domain forever. A day comes when the term of protection expires. All the rights flow from private domain into public domain. They may become generic, they may become off patent, so on and so forth. I try to give, a small table reflecting the kind of IPR, then whether registration is mandatory or not, then to what extent, in fact, what is the term of protection. Please look at geographical indications. We are talking about the advantages of compulsory registration, and once a GI is registered in respect of any manufactured goods or natural goods or agricultural goods, it is protected for 10 years and which can be renewed for many years. For example, when we talk about Roquefort cheese from France, when we talk about champagne from France, or Tuscany olive oil from Italy, or Swiss chocolates, the protection in case of geographical indications is still continuing. This is because of the registration, early registration and its renewal from time to time, of course, depending on the national laws. But right now, we also have an international legal regime, which also touches upon the protection to geographical indications for not only these goods, but also wines and spirits, which can be seen from the agreement on trade-related aspects of intellectual property rights. Well, when we are talking about the IPR protection to various kinds of goods, especially the protection which is given to geographical indications, what we need to understand is that we are talking about certain unique characteristics which are reflected in the goods. When we talk about Pashmina Kashmir shawl, when we talk about Mysore silk, when we talk about the sparkling wine, that is, champagne from Paris, or when we talk about Paris perfume, or when we talk about Florida oranges, certainly there is something unique about them. The uniqueness is probably because of two reasons. One is mostly because of geographical factors like the environment in which such products are produced, then the rainfall and other climatic conditions, the soil condition, so on and so forth. That is one. If you want to grow basmati rice in Karnataka and Telangana, it may be difficult to get the same kind of quality as we get in the Himalayan foothills, where the best quality of basmati rice is produced, right? Therefore, basmati has become a GI now. It's one of the geographical indications of goods after 2003. And what is the uniqueness? How the uniqueness has come up? Like long aromatic, silk, the grains, long and aromatic grains of rice. They owe their, in fact, the uniqueness because of the climatic conditions, geographical factors. Sometimes it coupled with them, it may be some of the factors like the skill and expertise of the people who are living in a particular area. The expertise of people living in a particular area. When we are talking about degree work from bidder, but the artisans living there, they have given a wonderful touch as far as these, metal or the other related works and artistic creations are concerned. For example, even in Telangana area, we have, silver filigree from one of the districts called Karimnagar. So where we come across 3 or 4 families who can weave beautiful ornamental things with this, in fact, the silver, which is melted at a particular degree, almost like, you weave the clothes, they can weave even the idols, the, beautiful artistic things also. It is because of the expertise of the people living there. Either way, if the uniqueness is because of these factors, it can always be called geographical indication, and the law protects the, in fact, rights of those stakeholders, whether they are producers, whether they are authorized users, right? This is one important aspect. So as you can see, intellectual property regime also offers protection to geographical indications of goods. And these goods could be, as I already explained, 3 different kinds: agricultural goods, natural goods, manufactured goods. And as I already mentioned, in the good old days, they used to mention about only 2 things, GIs, in respect of GIs. One is appellation of origin, means from where, where the origin could be traced. For example, Paris perfume. So now you can't say that Paris perfume is produced only in Paris. It can be even in, Seshadripuram College, or it can be in Usmania University Law College also, doesn't matter. But the name got stuck to this particular kind of perfume because it was very famous initially. Appellations of origin is one, indications of source is different. You talk about Scotch whiskey from Scotland, right? So Scotland and Scotch whiskey are inseparable. We are talking about the source from which it is produced. So Nagpur orange, for example, you need not talk about Florida orange, Nagpur orange, French perfume, champagne, so on and so forth. And over a period of time, the quality and the reputation of the goods, their quality, their appearance, their nutritious value, or their artistic value, whatever, it is maintained for decades and centuries together. That is the reason why we have to protect the geographical indications of goods. Another point, as I've been making from the beginning of this interaction, that it's a collective property, community property. If I make an invention, I can get a patent for it, provided other conditions are satisfied. But if there are goods produced by a large number of people, groups of people, or associations of people, in such cases, especially if they satisfy all the required conditions of GIs, we get the GI protection as a collective property. Madam must be knowing better, Professor Estelle. In European Union, you come across the protection of GI being given in the form of a community trademark. So it's community which stand to gain. And another point is that no geographical indication can be really transferred by the authorized users or proprietors. It has to be only inherited. because it's a collective property. No single individual will have any complete right. Now you can see some of those things. I think they are very yummy, and you can see Swiss chocolates on your, on your screen left side, sparkling wine, champagne on its right, then Florida oranges on its right. Then you have even Bengali rasgulla, Tirupati laddu, Darjeeling tea, or Tuscany olive oil. Then you have Pochampalli ikat. Then we have Kanjivaram sari, Mysore silk sari, Chinese silk, Mysore sandal soap. You name it. These are some of the geographical indications of goods. And this is the result of commercial exploitation of these. Please try to understand. Commercial exploitation of GIs. In many cases, in fact, commercial exploitation has been successful. There may be a few failure stories as well. Then, another important point is that when we are talking about the registration of GI, why do we register? Not for the sake of only record, but for the sake of commercial exploitation, for the purpose of ensuring that the benefits of commercial exploitation reach all the stakeholders. So here you come across number of such benefits. Legal protection is granted, one. Second thing is unauthorized use is prevented. Third thing is, in fact, even exports are encouraged. Then we have economic prosperity of the producers of goods, who produce in a particular territory. Examples I have already given. I have shown the photos as well. Then, of course, who can get a GI, geographical indication? Again, as I already mentioned, any association of persons, producers, organizations, even government also can do that. For example, in Telangana area, elsewhere Andhra Pradesh, we have Pochampalli ikat. That Pochampalli ikat was registered by, in fact, the Pochampalli River Society under the tutelage of the government of Telangana, Andhra Pradesh at that time, which seeks to protect the interest of the producers. So, the protection may be in many things, many areas. In production, only authorized people can produce. Even in processing, trading, and dealing. So, different areas, different stages where one can get the protection. For example, in the case of natural goods, the exploitation of the natural goods or in the trading and dealing of the natural goods. Same is the case with handicrafts and industrial goods. Who can make, for example, handicrafts? Take the case of handlooms. You talk about, for example, we have a Pochampalli ikat in this area. Then there is a conflict between the producers of these saris who use power looms and who use handlooms. Geographical indications normally are given to only those people who use their technical skill and expertise. Maybe, the actual weavers who should get protection, but they may be getting a challenge from others also. Is another important point. Then there are 34 classes of goods to which these GIs can be registered, in respect of which GIs can be registered. Few of them I try to give. It may be chemicals, it may be rubber, it may be textiles, I mentioned just now. It may be meat, fish, poultry, right? For example, it may be coffee, tea, cocoa, Darjeeling tea, for example, happens to be the first registered geographical indication in India. Then agricultural products, horticultural products, then even alcoholic beverages. There are different kinds. These are only major classes, please. Under each, there are a number of subclasses. And the registration can be done under any of these. Then, as far as the law is concerned, there is a recognition of geographical indications as a kind of industrial property under the intellectual property regime by the Paris Convention way back in 1883. Though the term used there is only the appellation of origin, one term appears there. Then similarly, we have a special agreement at the international level called the Lisbon Agreement on protection of appellations of origin, and for their international registration also. 30 countries are members. India is yet to become a member. TRIPS Agreement, which revolutionized the way in which IPRs are treated in all the countries, also recognizes the need to protect the geographical indications of goods generally, and also for wines and spirits under Articles 22 to 24. And we also have a special law. of 1999, which, however, came into force in September 2003. So that's almost 18 years back. People always remember the story of basmati rice, which is grown in India and Pakistan. And when a company in Texas called Messrs. Rights-8 Inc. Incorporated wanted patent for a particular kind of basmati, which was genetically engineered or modified, we opposed, saying that patent protection cannot be given because it is already in the public domain, so on and so forth. Ultimately, we succeeded. Later on, they started using the word mati for other kinds of rice. So American basmati, rice mati, tex mati, like that. Then again we objected, stating that this is, in fact, typically Indian. But this time India could not sustain its objection for the simple reason that the USPTO ultimately declared that mati is something which has become generic. So India has lost its mati. Mati means brain, not in that sense. But today, the use of mati is used in respect of other kinds of rice. Then they asked, then we said, no, this is a geographical indication. Then again the question was, where is the law? Under which law you have registered this? At that time, there was no law. I am talking about a development which took place sometime in 96, 97. Thereafter, to give effect to TRIPS agreement, this law was passed. Today, this law is working well, I can say, but life has to be infused into its working. Then another point, we are talking about the commercial exploitation of intellectual property, especially geographical indication of goods. You can see that UNCTAD, that is United Nations Conference on Trade and Development, found out in one of its studies that the consumers are ready to pay a premium of up to 10 to 15% for GI registered agricultural products. For example, we go for, certain unique products which are found in some departmental stores, which are 2 or 3 times costlier than the other ones. Why? Because of quality, because of something else. Same is the case with the non-agricultural products. You can say it is branding of those goods, agricultural goods, or, in fact, natural or manufactured goods. Small example you can see. Take the case of Darjeeling tea. In fact, it is one of the most unique kind of teas produced in Darjeeling area of West Bengal. First to be registered, and you will be happy to know that more than 70% of its total produce is exported. More than 70%, right? And the countries like Japan, Russia, US, and UK, and including many countries in European Union, they use Darjeeling tea. And what is the specialty of Darjeeling tea? Again, you can see, the kind of atmosphere which prevails there. The tea gardens, how it is collected, how it is processed, everything matters. But the net result is a unique quality of this tea. Even leaves are sold, you must have seen. And the logo was also created sometime in 1983. We also have some certain other stories. Chanderi sari, for example. And we also have the story of even, Hyderabadi Halim. Those students, I think maybe most of them may like Hyderabad Halim. Because Halim may be vegetarian or non-vegetarian. Even in non-vegetarian, you have, mutton, chicken and all. But I remember that till few years back, this product Halim, which is a highly nutritious product, made from, in fact, certain unique ingredients, and flour, wheat, this and that, then mutton, chicken, whatever, or even some vegetarian halim. This was available only during Ramzan month. But what happened in Hyderabad was that Pista House is one of the leading restaurants in Hyderabad. The owner of Pista House succeeded in forming an association called Hyderabad Halim Manufacturers Association. Then he applied for registration of Hyderabad Halim as a GI, geographical indication of goods. Before that, he did his homework very well. Like, the Meat Research Institute gave a certificate, and the other experts, they gave their own opinion. It was laboratory, tested. Ultimately, the registration was given. What is the net result today? You will find Hyderabadi Halim everywhere throughout the year, not only during the Ramzan month. It is exported. You'll find it in New York. You'll find it at Majestic, Bangalore railway station. You will find it in Delhi, Dubai, everywhere. And it is one of the most successful stories of commercially exploiting, the Hyderabadi Halim. There are a number of such instances. But there are some, in fact, failed stories also. Reason is this. Law is there. Policies are there. And groups are formed. GIs are registered. Only problem is the enthusiasm with which the registration is made is not followed up with the post-registration protection. There are certain limitations, right? Because gone are the days of thinking that champagne only comes from France. Tuscany olive oil comes only from Italy. That's not the case today, because we are talking about the country of origin. That is one aspect, the country of consumption or exploitation. Exploitation or consumption of the product can be taking place anywhere. Don't think that it is confined only to the stores in international airport. You will find in a corner some GI products, right? So this is one issue. Unfortunately, the generic terms, because once they become generic, then the uniqueness is lost. Like Mati, I mentioned already. Then similarly, another point is registration is made. But what happens? Take the case of Banarasi saris. Very unique saris. They used good quality raw material. And unfortunately, the price was very high. But in fact, the labor was also quite extensive. Investment also was quite extensive. The net result was that many people did not find any buyers. Many of them committed suicides also. That was in Banaras. Then what happened? Another point is, a cheaper version of Banarasi saris came up in the form of Kerala saris, Surat saris, China saris, and they used powered looms, not hand looms, right? Net result is that now these people now Banarasi sari has been registered as a GI. Even after that, these people try to maintain the same quality because of their expertise and all. But unfortunately, the other competitors were more powerful. They in fact, had chosen some shortcut methods. Net result is that they lowered their prices. The original makers of Banarasi saris also had to lower their prices. When they wanted to lower their price, they wanted to lower their investment also. So cheap quality material came to be used. What is the net result today? The real Banarasi sari is not available. The quality is dwindling. And neither the government nor these associations could prosecute those persons who are, in fact, trying to infringe these geographical indications of goods. Same thing happened in the case of Venkatagiri sari, Pashmina silk shawl. There are so many. This is another important point. And as I already said, sometimes, there is a lot of confusion between words like uniqueness, speciality, and all. Nonetheless, I think if the government is diligent enough, if these organizations are diligent enough, at the groups which get this registration, certainly the GI registration can lead to successful exploitation of the GI products in India and abroad. And it will bring a lot of change, positive change in the lives of all those artisans, etc. Take the case of Tanka paintings in Sikkim. Some of the tribes there, Lepchas, Putiyas, and Nepalis. So they are experts in Tanka paintings. These paintings are used, on mattresses and other things. Point is very simple. Where is the commercial exploitation? There is traditional basketry, there is traditional, puppetry, textiles, what not. But why, in fact, most of them are not successful stories. Reason is this. One is lack of effective regulation. lack of effective enforcement, lack of awareness, then improper or irregular settlement of disputes through courts. Unfortunately, that is the reason why people are asking for some kind of alternative dispute resolution. They want the matters to be settled, disputes to be settled at the earliest, so that the genuine stakeholders' rights are protected. This is another important aspect, friends. So there are a number of issues with regard to successful stories. We have Darjeeling tea, Hyderabadi Halim, Pochampalli Ikat, about 30 plus families. I think they are living a decent life today. Bengali Rasgulla, Rasgulla is a wonderful sweet. But Odisha people complained about the grant of GI tag to Bengali Rasgulla. Later on, they also got their own Rasgulla, Odisha Rasgulla. Now they are competing with each other as to which one is sweeter or more, in fact, tasty and all. So this is one important aspect, dear students. So during the time given to me, I think I could justify, whatever time is given to me. Now I think that a stage is set for even some kind of interaction. If any one of you or any of you have any questions, I'll be too happy to answer. Thank you, organizers, Professor Satish, Professor Ashok, Professor Darepa, and others, and thank you, students. Over to you, sir.